Good evening, everyone. My name is Michael Bindis. I am the president of the Puget Sound Lawyers Chapter of the Federalist Society, and on my behalf and on behalf of our executive committee, it's my pleasure to welcome you to tonight's debate between Justice Richard Sanders and his challenger Charlie Wiggins for position 6 on the Washington Supreme Court. We're excited about this event, not just because of the two great candidates we have, but also because of the great panel of questioners that we put together for this evening, who really present, I think, a great cross-section in terms of their kind of professional experience as well as ideologically. And to that end, I'll run through our panel members here briefly. Starting from the audience's right, we've got Professor David DeWolf of Gonzaga Law School. Professor DeWolf teaches torts, criminal law, and other subjects at Gonzaga. He holds a BA from Stanford and obtained his law degree from the Yale Law School. To Professor DeWolf's right, the audience's left, we've got Peter Callaghan, columnist with the News Tribune, where he's covered political, judicial, and other issues since 1985. Peter has his BA in communications from the University of Washington. And to Peter's right, the audience's left, we've got Professor Stewart J. of the University of Washington Law School. Professor J. teaches various constitutional-related courses at the UW. He obtained his AB from Georgetown and his law degree from the Harvard Law School. Talk briefly about the format we're going to follow tonight. We're going to begin with roughly 2-minute introductory statements from each of the candidates, and we'll have a coin toss to determine who goes first. Subsequent to the coin toss and the introductory statements, we'll begin the questioning from our panel members, and we will stick to a, I wouldn't say a rigid format, but we'll leave way for improvisation if we need to. But generally, we'll have a question from one of the panel members, an answer from the person to whom that question is addressed, followed by a response and a reply if the original person answering wishes to make a reply. Should the questioner feel that a follow-up question is necessary, we'll accommodate that as well. We'll repeat that process, making our way from panel member to panel member. And time permitting at the end, the candidates have very graciously agreed to take audience questions as well. We're going to do that, probably the best way to do that is by note card. You'll notice that each of your tables are a few note cards and pens. Because we're not going to be able to get through everyone who will have questions, if you could, during the course of the event, if you have a question, fill out the note card with that question. And perhaps the best way to do this is if you can hand them to Madeline Roach in the back. She can gather those and bring those up to me toward the end. And we'll, depending on the amount of time we have, we should be able to get through a few of those audience questions as well. Finally, we'll wrap up with closing statements. Going in order opposite of the opening statements. So, but before we get to the coin toss and those opening statements, let me just introduce the candidates themselves briefly. To the audience's right is Justice Richard Sanders. Justice Sanders was elected to the Washington Supreme Court in 1995 and won re-election in 1998 and 2004. He's authored more than 500 opinions during that time, and he currently serves on the court's Rules Committee and Budget Committee. Before joining the court, Justice Sanders maintained his own trial and appellate practice, litigating numerous cases involving property rights, civil liberties, and other issues. Since taking a seat on the bench, Justice Sanders has served as an adjunct professor teaching appellate advocacy at the University of Washington Law School and has guest lectured on state constitutional issues at Seattle University Law School. His writings have appeared in academic journals, including the Gonzaga Law Review and the NYU Annual Survey of American Law, as well as in legal texts, including In the Name of Justice. Justice Sanders earned his BA and his JD from the University of Washington. And to the audience's left, we've got Justice Sanders' challenger, Charlie Wiggins. For the past 14 years, Charlie has maintained his own law practice, Wiggins and Masters, on Bainbridge Island, focusing on civil appeals and regularly appearing in both state and federal appellate courts. Prior to forming Wiggins and Masters, Mr. Wiggins served as a judge on Division II of the State Court of Appeals, to which he was appointed in 1995, and prior to that spent 18 years in private practice in Seattle. Today, in addition to maintaining his practice with Wiggins and Masters, Mr. Wiggins serves as a pro tem judge for the Jefferson County Superior Court and is active in the Washington State Bar Association, having served on the Court Rules and Procedures Committee, the Court Congestion and Improvement Committee, and the Disciplinary Board. Mr. Wiggins received his bachelor's degree from Princeton University, which he attended on an ROTC scholarship, after which he spent 4 years as a military intelligence officer in the United States Army. He obtained his MBA from the University of Hawaii and his law degree from the Duke University Law School. Would you please join me in welcoming the candidates and our panelists? And as I mentioned, we'll begin the opening statements with a coin toss. And if it's all right with you, Mr. Wiggins, if I let Justice Sanders call it in the air?
Absolutely.
Justice Sanders, go ahead.
Heads.
It is heads. So we'll start with Justice Sanders.
All right. Well, I want to remind our distinguished inquisitors here, Professor DeWolf, I am the Catholic candidate. Mr. Callaghan, Tacoma is my hometown. Professor J, I did go to the UW Law School. In fact, I played in the Rose Bowl, albeit the French horn. I got a lot of playing time. I have served on the court for 15 years. I've had a great time. I consider the most important role of the court is to, as described in Article 1, Section 1, to fulfill the promise that governments are created to establish and protect and maintain individual rights. And I see most of the cases that go through the court in that framework. There's no greater defender of civil liberties across the board on the Washington State Supreme Court than myself. There's no greater advocate for open government or for construing the Open Government Act as the legislature says it should be construed than myself. I take pride in attempting to protect the citizens' right to keep and bear arms, their right to hold private property and to use it, and to foster a good business climate through rigorously enforcing rules and regulations regarding private business. I have a great support in the business community. I was endorsed by the AWB, and I have a number of union endorsements because of my support of the rights of workers in the workplace. I've been endorsed by leading Democrats like Phil Talmadge, Wes Ullman, leading Republicans like Rob McKenna, also received the endorsement of the state Republican Party. One of my most memorable cases in the Washington Supreme Court was when Ralph Seeley, a Tacoma lawyer and journalist, was dying of cancer. He sought to vindicate his constitutional right to smoke medical marijuana on his deathbed. He won in Pierce County, but on appeal to the state Supreme Court, he lost his case 8-1. And you guessed it, I was the one. Shortly thereafter, the Seattle PI published my dissent almost verbatim. They did not publish Justice Matson's majority opinion, much to her chagrin. But Ralph Seeley wrote me this letter shortly before he died. He said, "I was very impressed with your work. I recall thinking as I read through it the first time, damn, this is so well written, it's a shame only about 30 people will ever read it." Then the Seattle PI ran it as an editorial, and it literally made me laugh. It's not better than winning, but it sure makes losing feel better. So that's the way I feel about writing that dissenting opinion for Mr. Seeley. It's not better than a majority opinion, but it sure makes losing feel a lot better.
Mr. Wiggins.
Thank you. I want to thank the Federalist Society for hosting us tonight, or the Puget Sound chapter of the Federalist Society, and thank our panelists for being here, and thank each of you for your interest in this race. And I don't know where I should look for time. Are you keeping the time on this, or?
We're going to give some leeway if we get to a point where we're going on far too long. I may jump in, but I'd like to have as much of a conversation as possible.
Great. I'll expect a hook if I go on too long. Justice Sanders mentioned that he played in the Rose Bowl, and I want to add one of my college activities as well. I not only graduated from Princeton, but I'm a graduate of West Point. When I was young, my father, who was in the Army, was stationed at the military academy, and I graduated from West Point Elementary School. And so I have that credential, and somehow Mr. Bendis omitted that. I've practiced law for over 34 years, and you heard a little bit about what I've done. I've served as a Court of Appeals judge on Division II in Tacoma. I've served as a pro tem Superior Court judge in Port Townsend in Jefferson County, a one-judge county. I've served also as a pro tem judge here in King County, our largest county. And I have a word of advice for you. If you ever have the choice of serving as a pro tem between Jefferson County and King County, pick Jefferson. It's really a great place to be. I've had a lot of activity in the Court Rules Committee, the Disciplinary Board. I've been a volunteer within my community as well. I've lived on Bainbridge Island for over 30 years, or about 30 years, where my wife and I raised our 2 children. My daughter Amy is here. She's working on the campaign. And I was asked by Habitat for Humanity to organize the lawyers of Kitsap County to build a habitat home for a single mom, which we did, and then we were asked to do that again. We built one in Suquamish as well. Great experience. Had the opportunity to do other community work as well. I have been given the highest ratings by the King County Bar Association, higher than Justice Sanders, exceptionally well qualified, by the Pierce County Bar, the Latino Bar, the African American Bar, and the highest rating by the King County Municipal League as well. I've been endorsed by the State Democratic Party, but I've also been endorsed by some prominent Republicans, John McKay and Mike McKay, former U.S. attorneys. And I've also been endorsed by the longest-serving Republican officeholder west of the Mississippi. For the last 38 years, Dave McEachran has been the prosecuting attorney of Whatcom County. And he, along with 30 other of our elected prosecutors, endorsed me in this race. Over 80 judges have endorsed me as well. Been endorsed by the Council of Police and Sheriffs, the state troopers, by the State Labor Council, and by quite a number of unions as well. I've been endorsed by the Washington Conservation Voters, by the League of Education Voters, by a number of other organizations, the Retired Public Employees Council as well. I'm running for office because I believe in public service. As I mentioned, my dad was in the Army. I was in the Army myself. Public service has always been an important part of my life. And I think my record, my background and experience has prepared me for this position. And I'm anxious to ask for your vote on November 2nd and to serve you as your next Supreme Court Justice. Thank you.
And we'll begin the questioning with a question from Professor DeWolf.
Good evening. This is a question for Justice Sanders. Do you believe that the phrase judicial activism refers to a significant problem within the judiciary? And if so, how do you identify an opinion that displays judicial activism?
I think an opinion that displays judicial activism is an opinion I disagree with. Now, I think that judicial activism is an overused phrase and that it's usually used for exactly that purpose. I think it would be a lot better to talk about opinions that with which we find fault than trying to label them judicial activism, because that's some people think that judicial activism is finding a statute unconstitutional. For example, if that's activism, that may be good activism, like it is the role of the court to perform judicial review. It's the role of the court to make sure the legislature and the executive branch stay within their constitutional mandate, and when they step out from that, when they start violating the constitutional rights of the citizens, it's the responsibility of the court to say no and to find that their activities are unconstitutional and protect the private citizens of our country.
I think that the term judicial activism is one of those catchphrases that you do hear, and I do think that sometimes people apply it to any case that they don't like, but I think there are earmarks you can look at to see if a case is judicial activism. And I would say the heart of that is if the judge or the writer of the opinion has departed from the legislative intent in a dramatic way and has essentially rewritten the statute. Let me give you an example of that. It's an opinion by Justice Jim Johnson of McClarty versus Totem Electric. There's a case where our statute, law against discrimination, did not provide a very workable definition of disability for purposes of discrimination. And the Commission on Human Rights, I believe it's called, had the responsibility of developing regulations, developed regulations to define that. In the McClarty case, Justice Johnson basically swept away the definition by the Commission and adopted a federal definition which was less protective of workers and less protective of disability. Now we know that that didn't reflect the legislative intent because the legislature immediately overturned that decision by a statutory change. I think Justice Sanders, who joined in that opinion and may have something to say about it, I think that is an example of judicial activism.
Justice Sanders, would you like to reply?
Well, I can't recall the specifics of the case, but I think it is illustrative of the fact that the legislature can act when we come to statutory interpretation. Therefore, the court, I think when it comes to constitutional interpretation, that it's difficult for the legislature to act, and therefore the court has to get it right the first time, and if they don't get it right the first time, they have to come back in some future case and correct it. But if we misconstrue, as Charlie thinks we did, a statute, it's an easy matter for the legislature to come back and pass an amended statute.
Okay. Next question goes to Peter Callaghan.
Okay, and I think I'm technically addressing this to Judge Wiggins, is that correct? Okay. You can start with it, but it's really for both of you. And it's about the role of the dissent. I'm going to read something first that was said about Justice Sanders, and then I'm going to read something that Charlie Wiggins sent to me in a note about the same time. This was something written in an article called The Mind and Faith of Justice Sanders by Leonard Schroeder. And he was quite complimentary at that time. This was written during your first term of your passion and vigor in your dissents. And he said, "The only great justices are great dissenters. You're a bureaucrat if you do something else. I love the dissenters. They often make good law because they go against the stupidity of the majority." And I forget the context, but about the same time, Judge Wiggins, you had sent me a note on this same topic, and you said, "I think that some level of dissent is healthy. It serves as an important check on the judge writing a majority opinion and encourages change and development in the law." But you went on to say, "Too many dissents and concurring opinions send the message that the law is unpredictable, which I think erodes respect for the law and encourages litigation." With those as prompts, could I get you to discuss what you think the legitimate role of a sitting justice in writing dissenting opinions?
Well, I think that it's a matter, there's some conflicting considerations here. One is that each judge has to follow that judge's light in terms of interpreting a statute or interpreting the Constitution or interpreting and developing the common law. And a judge, you don't want as a judge to back away from or give up on something that's fundamental and important to you. At the same time, on a collegial court, I think that judges need to be aware of the fact that they are functioning, well, as a collegium. And they need to listen to one another, and if a judge is frequently, overly on the dissenting end of things, I think it's time for a judge to reevaluate and to ask himself or herself, are the other 8 justices wrong or am I wrong? And I do think that it is the obligation of judges to work together and to try to reach well, maybe this is a matter of style. I know that my experience on the Court of Appeals was we tried to reach a consensus and tried to forge an opinion that would be clear and that would give direction to the future and decide the case justly on a ground that we could all agree on. And I think that is the responsibility of judges, is to try to reach that agreement, just as it's the responsibility of jurors when they sit as a jury to listen to one another and to consider one another's opinions seriously and not to take an unreasonable position.
Well, I think if we wanted consensus, we could reduce the size of the court to 1 justice, and we'd have a unanimous opinion every time. That's obviously not the idea of the Founding Fathers. I believe that they thought there was strength in numbers, strength in different points of view coming to the table. There is a provision where we can file dissenting and concurring opinions. Personally, I'm a team player, but sometimes it's hard to get the other guys on the team. That's the problem. The collegial court, I think, is a court that talks to each other. My goodness, we do more talking than I can describe to you today, and my law clerks are here, and they know how much paperwork is circulated back and forth. Draft after draft after draft is circulated. People change their opinions. They respond to the other side. Sometimes they change their result. I remember on at least one or two occasions I had the majority, and a dissenter convinced me that I was wrong, and I signed their opinion and let somebody else write that majority. So I think that the most important thing is protecting the rights of the citizens and being right. And trying for a consensus in every case is not realistic, and if it were, it could only be achieved by dumbing down these opinions, when really we want to have an intellectual dispute. We want to be able to set out the two sides, and I want to be able to say why I'm right and why the other 8 are wrong. Charlie?
Well, I guess, everyone does decide cases by their own lights. I would observe that Justice Sanders is in the dissent in over half of his opinions, and I think that calls for evaluation of whether that's an appropriate role in the court.
Well, half of our opinions are unanimous, Charlie. I'm in the majority 70% of the time. And that's a Evergreen Freedom Foundation website statistic. They analyze these things. I don't worry about statistics, but other people do, so that is the statistic.
Sir, actually the Evergreen Freedom Foundation website that you referred to recites that you wrote more dissents last year than you wrote majority opinions. That's the point I'm making.
Well,
Next question.
That's absolutely true. That I wrote more dissents than majority opinions. I think Justice Madsen wrote more dissents than majority opinions, and there's a reason for that. And there's a glass ceiling on the number of majority opinions you can write. It's about 15, because they're randomly assigned throughout the course of the year. We have 135 cases. Divide that by 9, and each justice does 15 more or less. But you can write as many dissents as you want. And, when I come back from oral argument, my law clerks are looking at me and they're saying, how did we do today? And if I say, well, we did great, we didn't pick up any writing assignments, they go, hooray! So, yeah, that's the culture, I guess.
Our next question is going to come from Professor Jay.
Well, for the record, by your own count, Justice Sanders, you've written 146 majority opinions since 1996, 69 concurring opinions, and 363 dissents, which makes one wonder if you're protesting too much. I want to focus on one type of case that you've been most active, I think, in dissenting on, and that the area is the case law dealing with sexually violent offenders. You've filed over a dozen dissents in those cases, and frequently you're the sole dissenter in those cases. And I'm thinking, for example, about one case that was decided in 2009, individual named Paul Moore, who, just by the description in the case, is an extremely dangerous individual and had a long history of sexual violence, including while he was in custody. Nevertheless, you insisted, unlike your colleagues, that in order to detain him, that there be proof that it was likely that he would reoffend in the near future, not just at some point in the foreseeable future, but the near future. Doesn't that put the citizenry at risk, the very citizens you're talking about who are most in need of protection of the law? What I'm really wondering is, you seem to have a great interest in dissenting in sexually violent offender cases. Is there something about the commitment process for sexually violent offenders that especially concerns you in terms of its due process implications?
Well, there is something that concerns me about that, and that is that people are being incarcerated indefinitely, perhaps for the rest of their life, who have not committed a crime, or at least have served the time for the crime that they have committed. It is on the edge of, the court decided this was constitutional before I arrived on the court. I think that involved a dissenting opinion. I think that was 5-4 or 6-3. And the way the constitutionality of that statute was saved by the opinion of the majority in that particular case was to incorporate various safeguards to make sure that people were not deprived of their liberty unfairly. One of those safeguards was to require that they have committed a recent overt act during a period of time when they had an opportunity to commit a recent overt act. In other words, that they would not be committed based entirely on psychiatric testimony when they hadn't really done anything. There was a concern that they be given a right to a lawyer. There was a concern that involuntary treatment is not turned into punishment, because if it's punishment, that's a violation of the statute, and it's a constitutional violation which would bring civil commitment out of the civil and into the punitive or into the criminal. So there are any number of procedural safeguards that are in the statute and in the Constitution that pertain to these men. And I am unwilling to settle for anything less than those statutory safeguards that are there and the constitutional safeguards that are available to them in this practice of incarcerating people for basically what they think, based upon psychiatric testimony, that is often disputed, and often it seems to be there was a recent case, a recent dissent. No, it was a majority opinion where I wrote a concurrence, and I attached a copy of a affidavit from a psychiatrist out of California who basically challenged the testimony of the state's witnesses that this guy was committing acts, sexually dangerous acts, because of a mental disorder. He made the distinction between being a bad guy and going out and committing dangerous acts on the one hand, and committing them as a result of a mental disorder on the other, and he faulted the state's witnesses for not having any science behind their opinions that there was a causal relationship. So I think it's a complicated matter. It's easy to demagogue about this, but these are human beings, they're individuals, and I think the courts are there to protect the rights of even the most disfavored people, and those would be the sexually violent predators.
There's no doubt the courts are there to protect the rights of individuals and to protect constitutional rights. But at the same time, when you see a pattern that Professor Jay has pointed out, and you see such a consistent pattern of dissent from the other judges, I think you begin to see a judge who has strong beliefs he can't or won't surrender to the legislative will and to the legislative intent. And it goes further than just case decision, because Justice Sanders went down to McNeil Island and visited the Center for Sexually Violent Predators and interviewed people. I mean, talked to them. They were invited. All the justices were invited to come down, and only one went, and that was Justice Sanders. And this, in fact, led to his being disciplined by the Judicial Conduct Commission, a discipline that was upheld by a panel of judges. He was found to have violated the appearance of impropriety and failing to uphold the integrity of the court. And so I do think it's an unwillingness to go along with what the legislature has decreed, and I think that is a real problem in a judge.
Well, maybe my colleagues have that problem too, because a couple of weeks ago we found a legislative amendment to the enactment unconstitutional. The way these cases are tried is that a psychologist stands up and he offers testimony based upon actuarial tables that a man with this kind of record, this age, other factors is likely to reoffend in the future. And then the legislature amended the statute to say, well, if one factor changes, that's not a reason to let him out. And the court found, a majority of the court found, that that was a due process violation. So sometimes we should, I mean, assuming we were right, sometimes it's our obligation to disagree with the legislature. Charlie?
Our next question will be back with Professor DeWolf.
This one is for Charlie Wiggins. The Constitution sets out a series of boundaries, both federal and state constitutions, create boundaries for the powers of government. And over time, changes in social attitudes, changes in experience, create the desire, the need for redrawing those boundaries. So you have the Civil War amendments, you have the 16th Amendment that permits a federal income tax. As you look at the way in which the state and federal constitutions draw the boundaries for government today, what do you think is the area that is most in need of being redefined by some sort of constitutional amendment or reformulating of those boundaries?
Professor DeWolf, that's a really interesting question. That's a tough question too. You know, I have a concern, frankly, about the decisions of the United States Supreme Court on the issues that really swirl around campaign finance reform. And it's really the clash of First Amendment values versus the attempt by legislatures and by courts to maintain judicial elections in a way that will preserve the impartiality and the independence of the courts. And I think, I don't know whether a constitutional amendment, constitutional change is required or a personnel change is required, but I think that the court has gone way too far in terms of rejecting the efforts of the states to control elections of judges. And I'm in disagreement with the idea that, I'm in disagreement with limitations the court seems willing to place on campaign finance reform. I think that what the court did in the case in which they began to whittle away at the judicial canons as to what judicial candidate can speak, I think that the court seems to be willing to go too far. I think it's interesting that none of the judges on the Supreme Court have ever been to a judicial election, and really don't speak from experience about that. I'm not sure that's the biggest area that needs change, but it's certainly an area where I think that change is needed.
Well, I'm not worried about more freedom of speech. I am worried about other things that have been occurring since 1930s. President Roosevelt's attack on the court is 9 old men or the 4 horsemen of the apocalypse, and instructing chairman of the Ways and Means Committee to pass the Bituminous Coal Act without regard to its constitutional objections. I'm concerned about the expansion out of all recognition of the Commerce Clause, where a farmer can raise grain to feed his own livestock, and suddenly that's interstate commerce. I see that there was seemingly an effort to roll this back a little bit by at least requiring that the regulation have something to do with commerce and not be a traditional police power regulation, but that would seem to be short-lived. So I'm concerned with that. I think that we have virtually a completely different legal system, or a much different constitutional framework now than we had before the 1930s, but yet the Constitution hasn't been amended. We just have a different mindset on the U.S. Supreme Court. So, I would hope that there would be a return to original principles of constitutional jurisprudence, and if, for example, the Commerce Clause was envisioned as an attempt to create a free trade zone within the United States, well, that's the way it should be interpreted and applied, but that's kind of out of my hands. I'm a state court judge. I have to follow federal precedent, but I see that as a problem.
Mr. Callaghan, our next question.
Okay. I want to talk about smelly elephants, if you don't mind. In 2007, Justice Chambers said this in a concurring opinion. He said, "There's an elephant in the courthouse. The majority knows the elephant is there. The majority maps out a course around the elephant. The majority never acknowledges the presence of the elephant." That was 2007. My guess is the elephant is at least something you're smelling by now, whether you're seeing him or not. What he was talking about was his sense that there is a strong constitutional argument to be made that initiatives or statutes that require a 2/3 majority to pass tax increases are unconstitutional. 3 different times that issue was brought to the court, and 3 different times the court decided not to decide that issue. Now maybe you would consider this a violation of the prohibition on announcing a controversy, and so you can avoid talking about the 2/3 majority. But what's it going to take to get the court to decide a pretty significant issue? We're on the ballot again this year with yet another initiative on this thing that might be unconstitutional. Is it too much to ask the court to settle a vital, important, present constitutional issue?
I believe Justice Sanders is up now. So.
So much for the coin toss.
Well, if it's properly framed and the court doesn't have any choice, then I suppose the court is going to tackle that. They're going to decide that. Although the last time it arose, it had to do with the Lieutenant Governor ruling on a point of order that a bill, a taxing bill, could not be considered because it didn't have the 2/3 vote, and the issue was framed as whether or not we could order the Lieutenant Governor to make some sort of a different ruling, and we said no, that that's not the proper subject of a writ of mandamus, and that that this was a legislative matter, it was a political matter over which the court could entertain no original jurisdiction. Beyond that, the legislature can always amend initiatives, or at least after 2 years. So if the legislature thinks that an initiative saying that it requires a 2/3 vote to enact a taxing measure is improper, they can always just amend it. And apparently, they either agree that they'd like to have 2/3, or they'd just rather not stand up and be counted and send the issue across the street to the Temple of Justice, where it forced us to decide.
It seems to me that this question is a question of constitutional magnitude, and it's a question that should be decided by the court, not by the legislature. I don't think the legislature has to interpret the Constitution on this point. It seems to me that it's an issue that really should be resolved. We all know the initiative process is an extremely important part of our government, and we all know that much ink, many dollars, and many words are spilt over initiatives, especially in a year when you have so many on the ballot as we do this year. And I don't know why the court has tiptoed around the elephant in the room and has not talked about the elephant. I also think that you certainly see cases where the court reaches out and resolves issues that it doesn't need to. I think of the issue that arose, the opinion of Justice Sanders earlier this year on a minor who was found in possession of a handgun, and the question was that a violation of Second Amendment rights? And Justice Sanders, you wrote a long decision about whether the Second Amendment was incorporated in our due process rights, and then concluded at the end it was, but of course he's a minor, and the legislature had the power to regulate that. And so the court can certainly go out of its way to address an issue in a case like that didn't really need to be addressed, and they could certainly do that in the initiative, I would think.
Justice Sanders, would you like to reply?
Well, on the gun case, I think the problem was that the case was made by the litigants that the Second Amendment applied to the states, to my satisfaction. But having said that, they didn't make the case that the Second Amendment said that 17-year-olds would have a virtually unrestricted right to use firearms. And I said in the opinion that we reserve judgment on that until someone comes to court and wants to properly present the issue and brief the issue and inform the court as to what the rights of 17 or 16-year-olds are. There was a dissent. Justice Jim Johnson thought that we didn't need briefing on that, and he did some original research and wrote a persuasive opinion saying that this was a Second Amendment violation. But as for the rest of us, we felt that we couldn't take that step based upon the record before us in that particular case. So there you have it.
Our next question will come from Professor Jay.
I'd like to address this to Mr. Wiggins initially. I suspect both of you will want to say something. I'm going to mention a case and ask your opinion about it, and you can't wiggle out of this because this is not a case that could ever conceivably be decided by the Washington Supreme Court. The case is Lawrence versus Texas. Was it correctly decided in your mind? Now, we have no sodomy statute. We have no statutes of that sort that could possibly be at issue. It's been decided by the U.S. Supreme Court. The reason I ask is because, of course, it would help us understand your judicial philosophy about unenumerated rights in the Constitution. So, in your view, was Lawrence versus Texas correctly decided?
Lawrence, the issue in Lawrence v. Texas was the question of the constitutionality of the sodomy statute applied to people in private, consenting adults acting in private. And I think that it was a logical extension of the right of privacy that had been articulated by the U.S. Supreme Court. I think it probably would be decided that way under our state constitution as well, if Washington had addressed the question before the U.S. Supreme Court did, because we have a strong right of privacy in our constitution as well.
Well, let me follow up that just briefly, and Justice Sanders can think about this as well. In 1977, the Washington Supreme Court decided Gaylord versus the Tacoma School District. Mr. Gaylord was a high school teacher, a distinguished high school teacher in Tacoma. He happened to be homosexual. He wasn't out. The vice principal called him in one day and said that there was a story going around that he was gay. Was that true? And Gaylord said, he protested, he didn't want to answer, but then when pressed, he said yes. And he was fired as a consequence. And the Washington Supreme Court upheld the firing on the grounds that homosexuality was immoral. The lead opinion stated, generally the fact that sodomy is not a crime no more relieves the conduct of its immoral status than would consent to the crime of incest. In my mind, it's a rather shameful opinion. You still think it's good law after Lawrence versus Texas?
No.
Or is it ever possible for someone to be dismissed from a public position, a state position, say, merely because of their sexual orientation?
Merely because of sexual orientation as opposed to some action that they take or act on it, I think probably not.
Justice Sanders?
Well, I was encouraged by Lawrence versus Texas. Basically, it struck down a statute criminalizing homosexual activity between two guys in their own home, the privacy of their own home, basically the ground that the state did not have a legitimate interest in that kind of regulation. I was hoping that in subsequent cases the United States Supreme Court would run with the ball and would apply that rationale in other situations where the state has little or no interest in regulating the activity. I don't know whether it would have applied to our medical marijuana case that we talked about with Mr. Seeley or not, but it seems to me that that's Another example of the state interfering with the exercise of private activity when there's really no public benefit to it, whereas there's a terrific imposition on the individuals. And I would have liked to see the U.S. Supreme Court engage in a presumption of liberty. I think that was it Randy Barnett talks about that in his book. But so far they haven't taken the bait, but I think that would be a good way to go, so I was happy about Lawrence versus Texas.
But as a follow-up to that, as you know, the usually conservative criticism of Lawrence is that it found a right in the Constitution which isn't there. That is, it's pretty hard to imagine that the framers of the 14th Amendment thought that in any way it had implications for private homosexual conduct. In Anderson versus King County, you joined the opinion of Justice Johnson that very stridently held that in the case of the question of same-sex marriage, original intent had to be followed, and that the Constitution of the state couldn't possibly support such a right. So why don't we follow original intent in the case of sodomy prosecutions? Since you can't really argue that the framers of our due process clause or of the 14th Amendment had possibly imagined the result in Lawrence versus Texas.
Well, I think that we have a different situation in Lawrence versus Texas. We're testing on substantive due process grounds whether the state has a sufficient legitimate interest to regulate private activity. In the Anderson case, the primary argument was whether or not our state's opposite-sex marriage law, the Defense of Marriage Act, violated the State Privileges and Immunities Clause, which provides in general that if the alleged right constitutes a privilege or immunity, it must be equally available to all. Back in as early as Corfield versus Coryell, 1820s case that Mr. Wiggins doesn't particularly like, Bushrod Washington said that the definition of a privilege or immunity was a right held by all free people in all societies throughout the course of history, that it was a personal right. He gave some examples. And I did not see same-sex marriage to be reflected in that sense as a privilege or immunity. I think the case could be made for marriage in an opposite-sex context, but for same-sex marriage, I saw no historical precedent for that, and I saw that this was an area where the legislature had traditionally regulated. It was an institution the legislature created, that is marriage. It's an institution presumably the legislature could abolish, the legislature could amend it, the legislature could, it did, create another institution for same-sex couples when they passed the Domestic Partnership Act. So I think that there's a difference there.
I don't recall who it was. I think it might have been Professor William Anderson from the University of Washington Law School who wrote that the Constitution is somewhat like the banks of a river. They keep the river within its course. And I may be misciting this, but I think it was Professor Anderson. And that the Constitution holds the river within its banks, and the banks act upon the river, but the river acts upon the banks. And as well, sometimes the river changes courses slightly. It still has banks, but it does change course slightly. I don't think our Constitution should be regarded as a straitjacket that incorporates a view of liberties and of privileges and immunities that was announced in the 1820s before Washington was a territory, let alone a state. And I think that when our framers of our Constitution in 1889 adopted a Privileges and Immunities Clause, I think they were using language that came out of the 14th Amendment. And I think they were, for years, our Privileges and Immunities Clause was interpreted as an equal protection clause. And so I think it's a mistake to limit the language of the Constitution to exactly the way some of these words were intended in the 1820s. With respect to the Anderson case, I guess I've said before, and I would say again, I probably would have voted with the majority, with Justice Madsen's majority opinion in that case. But as I look at the Proposition 8 case out of California, where a judge actually sat and held a trial over whether there was a rational basis for the justification to limit marriage to same-sex or to opposite-sex marriage, and found all of the evidence wanting, I think it really calls into question the whole theoretical nature of the rational basis test as it was applied in Anderson and in other cases, and many other cases as well. And I think it probably does call for a reevaluation of that in this particular instance.
Well, what is the rational basis for keeping same-sex couples from marrying who are as equally committed to each other as opposite-sex couples? In Anderson, the Johnson concurring opinion stressed that homosexual couples can't have children, and that there's a tie to child rearing. Well, that's so obviously preposterous as a justification that it hardly needs refutation. Obviously, older people who are sterile can still get married. So what is the rational justification for preventing gays and lesbians from marrying?
Well, I think that what the judge decided in Proposition 8 was that those grounds were not rational.
I just thought you said a second ago you would have joined the majority opinion in Anderson.
Well,
that's why I was confused.
I think that is under a standard, the rational basis test has normally been interpreted, in my understanding, and I realize I'm talking to a constitutional...
It's the same standard in California as it is here.
Well...
They're both federal constitutional standards.
Well, Anderson, I think, was a state constitutional case, but here, certainly Proposition 8 was brought under the federal constitution. And now lost track.
Well, they're both raised. I'm not sure there's a huge difference in federal versus state interpretation of the process.
I guess I would think that the difference in the outcome in Anderson and the Proposition 8 case was the degree of deference given to whether you could conceive of one of these reasons as a rational basis. The judge in California actually held a trial on that, decided it wasn't rational. And that's not, to my understanding, normal.
Justice Andrews, would you like to follow up?
Yeah, I think that's an excellent question. Good discussion. I don't think rational basis has anything to do with the privileges of this argument. It has to do with whether or not whatever it is we're talking about is a privilege or dignity. This is not, these words just don't jump out at people. They have a common meaning. Technical, traditional legal meaning. They were mentioned in the original Constitution, the Articles of Confederation, as well as the 14th Amendment. There's been a lot written about what it means to be a privilege or immunity. I don't think that the Constitution goes down the side like a river. I think it does have banks, and I think it has limitations. I think words have meanings, and that, and this is not just, it was an 1820 case, but Justice Washington got it right. The Washington State Supreme Court has relied upon that. State versus Nance, I think Nance was a 1910 case. There's been at least 2 privileges in these cases since I've been on the State Supreme Court, where we have with the Grand County Fire Protection District, the Fire District, and the issue was, well, did the provision for annexation, which counted in property owners but excluded residents and non-property owners, would that violate their privileges and immunities? Ultimately, the court said no, that that's not the kind of personal right that is subject to the privileges and immunities clause. There's a subsequent case for that involving transport of construction waste here in Seattle. The Seattle government gave an exclusive franchise to Waste Management Inc. and Vanco Inc., saying that they could transport construction waste. The reason for that was that these large corporations demanded that sort of favoritism, so that they, because they were losing money from competition from other providers. The majority of the court said this did not violate the privileges and immunities. I wrote the dissenting opinion, I said it did. And economic protectionism, case law that I read back through the 19th century always uses economic protectionism as an example of a privilege or immunity violation. The slaughterhouse cases involved economic protectionism, and all the butchers had to go to the same place in New Orleans to do their butchery. So I think that one problem I have with some other members of the court, particularly Justice Manson, is that she will not accept that the Privileges and Immunities Clause really has a meaning distinct from the Equal Protection Clause. We don't have an Equal Protection Clause in this state. We don't need to deal with all these constructs of the New Deal Supreme Court talking about rational basis review, strict scrutiny, or the rest of it. If the words have meaning, that meaning doesn't change over the years, and if somebody doesn't like it, they can amend the Constitution. That's fine.
And we're on to the next question now, Professor DeWolf, for...
Perfect segue. The initiative process is an important way that the individual voter can initiate change when the legislature is not pursuing some issue that the voters care about. If there's a problem in the judiciary that the voters would like to amend by way of a constitutional amendment, there's no corresponding initiative process to amend the state constitution. Justice, would you favor the adoption of a method by which citizens could amend the Constitution the same way they can now pass a law?
No. I think that at least there would have to be a supermajority. I think it's too easy. It would make it too easy to defeat minority rights by allowing constitutional amendments to be that easily achieved. I don't think that the current system, it's not sacrosanct, but it certainly requires a super legislative majority. And then a vote of the people is very difficult to make the Constitution. Maybe we should have some other method, but I'm unwilling to allow the people a simple majority vote to amend the Constitution. I think that's dangerous. It means the Constitution is no more than sacred than a statute. That strikes me as inconsistent with the constitutional framework, the idea of having a Constitution.
We found a point of agreement. I think that it should not be easy to amend the Constitution. It should be difficult for all the reasons that Justice Sanders articulates, as well as stability of the constitutional structure. Now, maybe that could mean a supermajority by initiative, but I think the two-step process of both houses of the legislature approving of an amendment by a two-thirds majority, followed by a vote of the majority of the people, I think that's probably a good protection to include in the Constitution.
Mr. Callaghan.
Okay, we've got a full hour. We're going to talk about recusal, so I'm going to correct that. I think yesterday at your King County Bar Association, it was asked 5 times within the first half hour. So I think we were pretty disciplined today. It's been fairly clear, anyone who's watching this campaign, that you two disagree on this fundamental issue as to whether or not campaign contributions, particularly sizable contributions, in addition to sizable independent expenditures on behalf of a judicial candidate, should trigger recusal, should that party come before the court. So rather than going through that exercise again, I want to ask a couple of questions that maybe flow out of that. First, I think also at that debate yesterday, Judge Wiggins, you said that you didn't think endorsements should be considered. And I'm curious as to why necessarily that would be the case. The Washington Education Association gave no money, but loudly endorsed candidates such as yourself. sends notice to its 80,000 members, encouraging them to vote for you or to give you money. Why is that less of a conflict than writing a $16,000 check to you, for instance? And secondly, why shouldn't negative contributions be considered? Meaning, human nature suggests that a justice might be more likely to retaliate against an individual or an entity that tried to defeat them than they might be to reward one that tried to elect them. And I guess these are sort of worms that might wriggle out of the can once we have moved into this concept that monetary contributions and independent expenditures are grounded.
Thank you, Mr. Callaghan. The issue about financial support versus endorsements. There's a whole range of financial support, and with financial support, we measure many things with money in this country, of course. And juries measure damages in money. We measure the stock market in money. We measure people's status in money many times. And I think we're quite accustomed to having levels of money and pegging things to levels of money. And I think when personally, I thought that there should, as you indicated, I thought there should be a rule that if someone has spent more than a certain threshold of money, whatever that threshold might be, getting a judge elected, that it should be grounds for recusal. Now, the consequence of that is that you can still give money, you can still spend money to get a judge elected, up to a certain amount, and you can support the judge's campaign, because I think that's important. Money is important in these campaigns, and we need to have, I can't ask you for money, but I can kind of make an indirect picture that you should write checks to the candidates that you support. I think it's important to provide a means for candidates to raise enough money. If we don't have some cutoff, and we don't know where the safety zone is, you can't do that with an endorsement. And with an endorsement, it's either a yes or no. I mean, it's an on or off switch. And I do think one of the things I thought about and thought long and hard and struggled about with the recusal rule is you really want to continue to preserve the opportunity for judges to raise money. And so you've got to set things at a level where that's right. And I don't think you can do that if you have an on-off switch with endorsements. The second part of the question was why shouldn't negative contributions be considered? In other words, shouldn't you be able to ask a judge to recuse if you've supported that judge's opponent, I guess being the point. And maybe so, but we can't seem to get to first base in this ballgame. We can't even get a rule that says if you've given support to the judge who's sitting in front of you, we're not going to have a cutoff for that. We're not going to allow a motion for that. We're not going to, we're not even going to go there. So I think that what you're talking about in terms of negative contributions would certainly be an idea that's worth considering. But we need to get first to recusal based on parameter spending.
Well, my envelopes are there at the table. I think that Charlie and I have a philosophical difference about this. Charlie thinks that most problems can be solved by another rule. I don't think so. I think oftentimes when you have another rule, you just have another problem. It's sort of like whack-a-mole. During the time, the Washington State Supreme Court, I don't think there's ever been a single recusal based upon campaign contribution. Not a single recusal anywhere. I think that the debate is pretty much empty. It's based on a false premise, and that is that people don't give contributions to judicial candidates or political candidates because they hope they're going to do something different in the future. They give contributions to political candidates and judicial candidates because they hope that they're going to continue to be the same. Charlie has other forms. He's talked about getting the endorsements of 31 of our county prosecutors. I haven't seen a groundswell of contributions from these prosecutors to my campaign. hoping that I'll change my spots. I think that, and I think that raises another interesting question, and that is that here we have frequent litigators in the court supporting the candidate, and if he gets elected, the perception is that it's payback time. Now, I'm not saying that that's what would happen, but you could make the same argument over that as it would with the campaign contributions. So I think that also when we talk about recusal for campaign contributions, it's never going to happen in the state, even under Charlie's formula, because there's a campaign contribution limit. It's now $1,600 per person per candidate. No one claims that a $1,600 contribution should trigger a recusal. On the other hand, there's unintended consequences of this so-called campaign finance reform, and that is that the candidate who is strapped for raising money can be faced with an unlimited independent expenditure, like happened to Jim Johnson just a couple months ago. $350,000 was spent against him in the last few weeks of the campaign, and he couldn't respond because he could not raise enough money under our current system. Now, it was unsuccessful, fortuitously so, but that's a flaw. That's a flaw in this whole idea. It's also, if a candidate is independently wealthy, he can spend as much money as he wants, whereas the other guy, who has to rely on contributions, is held down to the point where he has an ineffectual campaign. So, Peter, I think that the ultimate answer to all this is just freedom, to leave the candidates alone. The system does not broke. It worked just fine until 2006, when this campaign finance reform came along. Then you saw $1 million or $2 million come in from special interests to try to influence that election. They were negative ads, they were irrelevant ads, they were nasty, they were misleading, and that didn't happen when people contributed to individual candidates who had to be responsible for the way their campaign money was spent. So I guess that, call me a traditionalist, but I believe in free elections.
May I respond to that? Justice Sanders is absolutely right about one thing. We do disagree quite strenuously on this. And let me point out a few things. The theory behind recusal based on campaign contributions is not just some corruption theory. The theory is that the public is distrustful of campaign contributions. Studies have shown over and over that the people believe that campaign contributions influence judges' decisions. Studies have shown judges believe this. And ironically, the very week that the Supreme Court signed off on an order that refused to adopt the meaningful recusal rule, the justice at stake issued the results of a telephone survey that was conducted nationally of 1,000 adults. And here's what they found. 71% of Democrats and 70% of Republicans believe campaign expenditures have a significant impact on courtroom decisions. 82% of Republicans and 79% of Democrats say a judge should not hear cases involving a campaign supporter who spent $10,000 toward his or her election. Now, the rule that the Supreme Court, our Supreme Court, refused to adopt put a $16,000 limit. Here's a study that says 80% of the people think a judge should not sit on a case if a party to the case has spent $10,000. So this is an issue that affects the confidence in the courts. That's what this issue is all about. Now, Justice Sanders says, well, this isn't going to happen. It's not a problem. We already have a $1,600 limit on campaign contributions. Well, the rule as drafted and proposed to the Supreme Court counted independent expenditures. Money that went into, that was spent independently, it counted money that went into a PAC and that you could trace into a judge's campaign or opposing the judge's campaign. All of that was considered. And so, but the Supreme Court, when it really took this rule apart, took that part out. That's why the rule won't have any effect now, is because the Supreme Court changed the rule. Justice Sanders says, there hasn't been a single recusal since he's been on the court based on campaign contributions. Well, why is that? It's because most judges do not look at who their campaign contributors are. They try not to know who their campaign contributors are. So how would they know that there has been large campaign contributions? Well, if a party filed a motion, says, Judge, you should recuse because of that. But the court has no mechanism for doing that. And in fact, there are motions to recuse that the court clerk has refused to pass on to the judges because they say, well, there's no authority for this. You can't move. So, of course, no one's recused because the judges don't know what the support is, and the court won't entertain a motion to recuse. Justice Sanders says, well, before 2006, there was not a problem with this, and no, we didn't see these big expenditures. In 2004, you saw hundreds of thousands of dollars by a special interest group going into one particular Supreme Court election. Hundreds of thousands of dollars. And furthermore, what is even more chilling is not just that that group supported that judge, but that one person, one entity, spent $100,000 to defeat a Supreme Court candidate. Why? Because that Supreme Court candidate was a Court of Appeals judge who upheld a $16 million judgment against that party. I don't know, I shouldn't say why, but I can tell you those are the facts. And so there were problems with this before campaign contribution limits were enacted by the legislature in 2006. We do disagree on this.
Well, back in 2004, there were 0 independent expenditures. Anybody could contribute anything they wanted to anybody's race. It's called free speech, Charlie. People have a right to do that. It's guaranteed by the United States Constitution, and there's nothing that you or I or the rest of the state Supreme Court can do about it. That's beyond our pay grade. When we talk about appearances, I hear this argument. I hear your argument, Charlie, that well, people think that campaign contributions influence judges. I haven't seen any evidence of that. I haven't seen any study showing that to be the case. But appearances, a lot of people think that David Copperfield can make elephants disappear. And I'm not interested in appearances. I'm interested in the truth. I'm interested in facts. And I think that that's what should guide the judiciary, not focus groups or polls.
And our next question, and this may be, depending on how the response goes, may be our final panel member question, but it goes to Professor Jay, and I believe it's directed to Justice Sanders.
Well, this discussion makes me ask the following question. Why isn't this just an astonishingly bad process for picking Supreme Court justices?
Well, I thought it was an astonishing...
You're right. There's nothing the Washington Supreme Court can do about the fact that the U.S. Supreme Court has said that you can spend as much money as you possibly want on your campaigns. And obviously, independent groups can spend enormous amounts of money. But that's not really actually my major concern. My major concern is that when these groups translate those donations into commercials on TV, for example, they are absurd. They do not in any possible way allow a voter to make an intelligent decision as to who should be a Supreme Court justice, much less any other judge in our system. How can we defend a system in which the average person has no idea why they are voting for one candidate versus another in a particular campaign? And just to give you some clarity on this, I mean, I spent the entire day before I got here reading Justice Sanders' opinions, dissents, I should say. I didn't read all hundreds of them, but there are a lot. And, I have a legal education. I could understand them more or less. How is the average person supposed to make an intelligent decision? We can, as voters, figure out whether we're spending too much money or taxing too high. But how are the average voters supposed to figure out whether or not your dozen or so dissents in sexually violent offender cases are correctly reasoned or not? I just don't understand how this process intelligently works.
Well, I don't think that people can go through these hundreds of decisions and figure out whether they're technically correct or not. I think that they can get a general idea of where the candidate is coming from, what his or her values are, whether they value civil liberties, whether they value private property, whether they value the rights of workers in the workplace, and you can have a generalized thinking about that. I think that in my races, there's been the same voting pattern in August as in November of August of 2010 as November of 1995, and I think that the voters of this state have a general idea of where I'm coming from, and that they so far, given that I've gotten elected, they seem to like that. So I think there's a consistency there.
And if you seriously think that the typical voter has read any of your opinions or is even aware of what any of your opinions actually have held?
I
The
doubt
great majority of voters.
I doubt if very many of them have read any Supreme Court opinions, but I tell them where I'm coming from,
And how many voters are you able to meet and tell like that and have them absorb the message?
not a lot in person, but through the campaign messages that we, to the extent we have resources to buy advertisements and campaign, we try to put a message out there to identify a constituency and tell them what it's about. And I think it's been successful. We don't see random voting in this state. We see consistent voting.
It's a matter of opinion.
Well, I've always done very well in Lincoln County. I got 70% in 2004, and I did real well in August. Nobody lives in Lincoln County. That's the downside. But those farmers understand what Justice Sanders is all about, and they like it. So maybe I don't do as well up on Capitol Hill, but I think that.
The real question is why the system shouldn't be one that more closely models the federal system, in which we have some sort of a merit appointment process, or at least appointments, say, by the governor, with Senate confirmations and an actual investigation into people's professional records.
I'm not always happy with our governor. Why don't we have merit appointments for our governor?
Well, because governors...
I'd like to be on the merit appointment
Because governors
committee,
run
the blue ribbon
on policy
committee.
positions, and things like raising taxes, spending money, et cetera, whereas you supposedly are running on issues dealing with how you interpret the Constitution, how you interpret statutes. Those are technical issues, or issues that they go beyond the average person's understanding of just how public policy should work.
Well, let's suppose that nobody knows anything about judicial candidates when they go to the polls and they vote randomly. Jerry Spence, in his book, *And Justice for None*, said that that's what we need, is more random selection of judges in our system. Because that will mean that not a single typeset or class of lawyers is going to dominate the system, and that individuals, once they get involved, will rise to the occasion and try to do a good job. He was worried about what he called elevator lawyers dominating the system. So there are 2 points of view on this, Professor, and I think that electing judges has worked out pretty well in this state. There have been some elections of Supreme Court justices that I thought were flukes. I didn't think mine was a fluke, but I thought that there were other examples that I could think up, and those individuals haven't been disasters. So, they go to the University of Washington Law School and have Professor J, and they have a good education, and
We hope for the best.
and we can hope for the best, right?
I guess I am not an adherent of the philosophy that a system that picked me must be good. Or that it picked a particular person to take the position. Gee, just because it picked me, it's a good system. I think that it's really interesting. I I have tried to teach people about electing judges and teach students about electing judges. And I've gone into Bainbridge High School, where I live, and for the last 8 years, every year I've gone in and talked to seniors who are graduating and are in an advanced placement government class, and talked about electing judges. And we go through and I talk about, here are the things you should look for. And frankly, I tell them, look for the qualities of the judge. I mean, look for integrity, look for impartiality, look for independence, look for these things. And then I always put up a case study. Okay, here's somebody from the last election, here's their voter's pamphlet statement, here's the other person's voter's pamphlet statement. Now, what do you see in here that tells you about any of these qualities? And it's remarkable how little you can find in the voter's pamphlet statement that really tells about the qualities you ought to be looking for in a judge. And ultimately, at some point, some student will raise their hand and say, why do we do this? This is really impossible. And it's exactly what you say. I really think that if voters, I think the average voter could pick a good judge and pick the best judge if the voter had enough time and had the resources and the information. The problem is, that's not real. That's not reality. Voters don't do that. I do think we've improved the sources of that through the efforts of Jeff Frank and others like him. And we now have a great website, votingforjudges.org. It has a great deal of information and can point you in the right direction in terms of judicial elections, and I'd recommend that site to anyone. But I think that, frankly, I think that the process of the election process changes the judge and the candidate as well as the audience, and I think that's a plus. But it's more of a theoretical plus than an actual plus. There's something really interesting about Justice Sanders' comment about randomly selecting judges. I don't think we should randomly select judges, but I do think that I'm kind of tempted by the idea that we ought to have a commission system where the commission is randomly selected. So they're more like a jury, and they vet the candidates, and they spend the time. And they have the time to study the candidates, and they make the recommendations to the governor. Here's the list of 3, and the governor picks off the list. That would be more like a jury system. We've done that for 800 years, ever since the Magna Carta. Maybe that would work. And actually, the legislature adopted just that system for the Salary Commission, where they picked people randomly to be on the state salary commission, and maybe that would work. The problem I have with a commission system is always who picks the pickers. And if you have a commission that has too much political influence built into it, it gets to be a problem, in my opinion. So, I'm real concerned about it, and you couple that with the fact that it's really hard to change the Constitution to go to some other system. I don't really know the best alternative, but I'd certainly consider a well-constructed commission system.
We're running fairly close to our time allotment here. I would like, with the candidates' permission, to accept a couple of questions from the audience, but given the short time frame, would it be acceptable if, rather than do the note card idea and have me go through them quickly, if we just have the audience members stand up and ask a question? Would that be acceptable? Sure. Okay. Do we have any takers? Sir?
Right now, one of the major issues, like federal courts, is wiretapping with cell phones. And what are your opinions on wiretaps and cell phones, not having to have a wiretap warrant? They have a wiretap. So they're using Homeland Security as the...
I guess I don't know enough about the issue really to speak intelligently to the issue. I'll just have to admit.
Well, I think I'm kind of in Charlie's position on that too. I don't know enough about it. I sort of have a knee-jerk reaction against it. In some ways, our state constitution provides more protection than the federal constitution. We had a case involving the police putting a GPS device on somebody's car without a warrant, and eventually he was arrested for it. They tracked him down, committing a crime. He was arrested, and we threw that conviction out. We said that violates our state constitution. It seems like recently some federal court, or at least there was a federal debate saying that, well, that should be okay under the U.S. Constitution. I don't recall whether there was actually a case on that or not.
Yeah.
but the U.S. Constitution does provide less protection in the Fourth Amendment than we have in our Article 1, Section 7. So I think we have a superior system, and that protection for the individual is really what the Founding Fathers thought about. They were worried about the overpowering, oppressive power of the state, and many of the Bill of Rights are not there to help law enforcement. If we didn't have a Fifth Amendment right against self-incrimination, I'm sure that law enforcement would be able to more effectively function, but the Founding Fathers made a value judgment there in favor of the individual, and I'm happy about that, and there you are.
Another question? Yes, ma'am.
Many cities and municipalities are taking property for economic development and by using eminent domain. So how do you feel about that?
Well, Professor Jay and I had a little debate before the Alumni Association at the University of Washington Law School on the Kelo decision. And he was gracious enough to put together a PowerPoint presentation for me. And what is implicit, I think, in the Fifth Amendment is expressed in the state constitution. We say in Article 1, Section 16, private property shall not be taken for private use. So usually these economic redevelopment schemes involve sooner or later transferring the private property of A to owner B, so that he'll build something on it, raise the tax base, etc. They can get away with it apparently under the U.S. Supreme Court, at least 5 members of the U.S. Supreme Court. But I don't think they should be able to get away with it under the state constitution, at least if words have meaning and the river hasn't shifted off its banks. So that's what I feel about it. My law clerks say, well, what do you feel about this, Justice Sanders? I said, I don't feel, I think. So.
I agree with Justice Sanders that our state constitution is more protective of property rights in restricting the right of eminent domain. It's certainly more specifically protective, as the city of Seattle learned in the Westlake redevelopment. And the original plan in Westlake didn't work out and was held unconstitutional because exactly what Justice Sanders describes, or what you described, happened. The city was going to condemn property and then basically turn it over, redevelop it and turn it over to private landowners, and they couldn't do that. And I think that was the correct decision.
Okay, time for one more, and I believe...
Yeah, this question is for Mr. Wiggins. My ears sort of perked up when you said that the elections process changes judges. I'm not really clear what you mean by that, and I guess could you talk about how the election process has changed you? And Justice Sanders, if you have thoughts on that, I'd like to do that too.
Well, thank you for that question. It's kind of interesting. This is a very humbling process. I mean, you basically go and lay bare your soul, and you submit yourself to questioning by, these great scholars, and sometimes you think, duh, I don't know the answer to that question. And so it's going to be a very humbling thing, and to go out and encounter citizens and talk to folks and distill, crystallize your message, it changes the way you view people. The other thing it does is it really forces a candidate to confront issues that you never may have really been forced to confront.